Good afternoon, and thank you for joining Department of Justice, Antitrust and White Collar Investigations, What You Should Know. This is the second CLE webinar in a series offering vital insights into antitrust issues and white collar investigations. This is an off-the-record conversation. Our program today will last an hour and is approved for 1 hour of CLE credit in California, Colorado, Georgia, New York, Texas, and Pennsylvania. New Jersey credit is available via reciprocity. Credit is pending in Florida, Ohio, Virginia, and Illinois. For all other states, attorneys can receive a certificate of attendance and electronic materials so they can file directly with CLE credentialing entities. During the course of the webinar, we'll share 2 codes that you'll need to enter into a brief CLE questionnaire immediately following the program's conclusion. Once the webinar has ended, please look for a small pop-up on your screen. Click Close for your CLE quiz to appear in your browser. Please make sure to answer all of the questions if you'd like us to submit for CLE on your behalf. If you have any questions during the presentation, you can type your questions in the bar on the right side of your screen in the questions area. We will try our best to answer them at the end of the program, time permitting. If not, we will follow up with you after the webinar to answer those questions. We will provide our contact information at the end of the program, so you can contact us at any time with comments, suggestions, concerns, or questions. We will also send an email to everyone in the next day or 2 with a link to the recording of the webinar.
Good morning, good afternoon. My name is Carl Hittinger. I'm a partner at BakerHostetler in the Philadelphia and Washington offices. I'm also the leader of BakerHostetler's Antitrust and Unfair Competition team. Today we're going to have a webinar webcast on the Department of Justice. Some of you might have been on our last webcast, which was last week, which dealt with the FTC. Today we're going to talk about the Department of Justice. Next Wednesday, we're having another webcast as part of this series, which will be about state attorneys general. Today we're going to deal with 3 subjects with 3 of my partners we'll introduce in a minute. The first is going to be about what is the Department of Justice Antitrust Division doing in criminal antitrust investigations at present. The second topic will be corporate search warrants and dawn raids, a primer for in-house counsel. And the third topic will be FCPA and the latest policies and prosecutions by the Department of Justice. As you know, some of you know, last week we dealt with the FTC. I want to just segue from that into this webcast just briefly. The FTC, as you may know, was created in 1914 as an independent agency to investigate consumer protection issues as well as antitrust issues. And it is apolitical in the sense there are 3 members that are one party, 2 members of the other party appointed by the president and approved by Congress. In that sense, it is independent. But nevertheless, you know, historically, some presidents have attempted to be involved in the activities of the FTC. Roosevelt tried to fire a commissioner at one point. That didn't succeed. Reagan tried to cut the funding of the FTC in half, which would have eliminated the Bureau of Competition and other things. That was rejected by Congress. So today, we're going to talk about the Department of Justice. Now, the Department of Justice, as you know, is part of the executive branch. And being part of the executive branch, it is subject to involvement by the White House and the president. And historically, that has been the case. And one of my partners will talk about this in a minute, but historically, you know, President Kennedy investigated the steel industry. At his prompting, President Truman decided not to investigate the oil industry for price fixing charges because he felt it was not in the interest of national security at the time. President Reagan had opposition from the breakup of AT&T by his Secretary of Defense. He overrode him, and they broke up AT&T. And more recently, President Clinton says that he knew nothing about the antitrust investigation of Microsoft until he read about it in the newspapers. Nevertheless, there have been issues involving the DOJ and FTC not necessarily agreeing upon which should be investigated because they both have civil authority. Department of Justice only has criminal authority, which we'll be talking a lot about today, but that divergence has resulted in turf wars between the 2 agencies, most recently involving big tech, which have resulted in some inconsistencies between those agencies in those cases. Qualcomm is an example that recently occurred. So with that context and that setup, I'd like to introduce our three speakers today. First will be Jeff Martino. Jeff is a partner in the New York office. He's the former chief of the Department of Justice's Antitrust Division in New York City. Also will be followed by Carol Rendon. Carol is the former U.S. attorney for the Northern District of Ohio. And finally will be George Stembolitis. George is first the co-leader of the BakerHostetler's white-collar investigations and securities enforcement team, and he is the former chief of the U.S. Attorney's Office in the Eastern District of New York in the Long Island Division. So these are very experienced former prosecutors and now in private practice representing clients. And with that, I'd like to turn it over to Jeff Martino to talk about cartel investigations. Jeff?
Great, thanks, Carl. And it's a pleasure to be here this afternoon. Thanks for everybody joining the call. In the first instance, because I just came over from Department of Justice, I do want to make clear that I won't be able to talk about the particulars of certain matters that were before me in the New York office, but I can speak on the law and policy, and so that's why you'll see that my presentation is at a higher level of what's been going on with the Antitrust Division on the criminal side. And with that, I'll just segue. What is a criminal antitrust violation? And that would fall under Section 1 of the Sherman Act that prohibits restraints of trade. And how the case law has come out is basically that if a competitor or two or more competitors agree to fix prices, rig bids, or allocate customers, that would be a per se criminal violation, meaning that essentially the agreement is the crime. Of course, a prosecutor will want to have more than just the agreement, but that's all that's needed. There's no overt act needed, which is unusual in criminal prosecutions. I do want to just also talk about price fixing. You don't have to actually fix a particular price. You don't have to agree that a widget is $1. Competitors can agree to limit supply. That would essentially raise price under the law of basic economics, or push price in a certain way. If competitors are agreeing to over time, gradually increase the trend of prices, that agreement is a violation under the Sherman Act, a criminal violation. And so, what are folks facing for a criminal violation? Individuals are facing up to 10 years in jail, and companies face fines of up to $100 million, or twice the gain and twice the loss. And so who is currently responsible for bringing these cases? As you see set forth in the slide, these are the key individuals at the Justice Department right now in the Antitrust Division. It's a generally new team. Makin Del Rahim is the Assistant Attorney General. His background is primarily in patents, policy, and lobbying. I think it's important to note that he's not necessarily a litigator, but he claims to be an innovator. And so some of the policies and roundtables and workshops that the Department of Justice is doing are really, at his behest on thinking through some tough legal issues. Now, he also was a former head of policy, appellate, and international back in the early 2000s under the Bush administration. He was a deputy assistant attorney general in the Antitrust Division. And so you'll see a lot of his work recently has been filing amicus briefs. And so I think that really stems from his early time in the division, head of the appellate section. And then he's also got a real push on the international front to try and get folks, other competition agencies, to abide by similar due process that we have here in the United States. So that's kind of the big picture on how he thinks about antitrust issues and what his priorities are. Richard Powers is the new Deputy Assistant Attorney General. He came on May 15th, 2018. It's just interesting to note his background because I think it'll be helpful if appearing before him, you understand where he comes from. He was in the Antitrust Division as a trial attorney, then moved over to the Healthcare Fraud Task Force out of the Eastern District of New York for some time, a couple of years before then being elevated to run basically the criminal program of the Antitrust Division. He's got significant experience in financial services cases while he was with Antitrust and worked alongside the fraud section in the LIBOR prosecution. Down the line, you have the directors, Marvin Price and Andre Gabarola. Marvin's been with the division for, I think, upwards 40 years. He may be the longest-serving career person that the division has at this point. So he brings a lot of institutional knowledge to criminal enforcement for the division. The director of litigation, that's really the director of criminal litigation, Andre Gabarola. That's a recent position that's been added by Macon. And I think it really demonstrates the emphasis on what the division is trying to do to improve its, basically its batting average is going to trial. Typically in criminal antitrust cases, they are hard cases to win at trial. I think overall maybe 50% have been won by the department, but they're trying to learn from those prior trials and get a better percentage on the wins. I think it's also interesting to note on each of the offices, sections, you have all new leadership within the last 2 years. Obviously, I left New York just this past summer. Joe Moyle is acting, but the other folks are relatively new to the position, but not new to criminal prosecution in the Antitrust Division. They are all seasoned trial lawyers who've gone to trial, probably all of them except for Ryan Danks and Jim Fredericks. Ryan has more of a policy background. He worked closely under the prior Assistant Attorney General and helped out with policy. Jim Fredericks came over from the appellate section. He was an assistant chief and appellate, but he was the criminal, primary contact for the criminal side of the house. The way it's set up, I think it's helpful just to know that each office has a geographic region that they are responsible for. So if a new complaint comes out of the Northeast, it'll be New York. Western states will be San Francisco. Midwest, Chicago. Southeast will be the criminal section 2. Mid-Atlantic is criminal section 1. That's not to say that they're limited to those jurisdictions. Assignment of cases is based upon resources, so you may get calls from across the country as well, but that's the general setup. I think what's important to note just generally about the division is that it's still, we'll talk a little bit about this as we move through the slides, it's focused on individual prosecutions and going after key executives, because it's the key executives who are traditionally the ones who enter into these agreements for their companies to fix prices or rig bids. They do take on difficult cases, and while they understand that they are going to be very difficult to trial, but if they've got a greater than 50% chance of winning, if that's their assessment, they're gonna go forward with the case. It's also interesting to note the investigative tools that they employ. They work closely with the FBI, other IGs, but they've got obviously authority to execute search warrants, not themselves execute search warrants, but seek search warrants. There's actually wiretap Title III authority that they have. They employ using cooperators, conduct consensual recordings with their co-conspirators or alleged co-conspirators. And so those are all the traditional law enforcement tools that they have in order to help build their cases. So what are really the themes? I've touched upon it before and what they're focused on. And here it's individual accountability. It's been recent that the department has gone out publicly and said that, but that has always, I think, been the focus in white-collar prosecutions, is focusing on individuals. And especially in the Antitrust Division, there's, I think, statistics that point out that they've basically prosecuted 2 to 3 individuals for every company that they enter into a resolution. And so really it's the key executives that enter into the agreement, and that's where the evidence leads them, and then that's where they're focused on. They're not going to trade off a corporate prosecution for individuals. And you see that really with what's going on right now. There's going to be 2 trials coming up, one against a CEO of Bumblebee out in San Francisco for the tuna cartel. And then also there's another trial here in the Southern District of New York against a former trader at JP Morgan in the Forex investigation. What another trend or theme that you see within the division is really a movement towards transparency and consistency. You've got the leniency program for the division, but that's also somewhat consistent with the FCPA unit and what they're doing there with declinations, and you're going to hear more about that when George speaks. But you also have the issuance of the recent compliance guidance that's come out, and George is going to hopefully get a chance to talk about that. But again, the division is trying to come in line with what other components are doing. So as I mentioned, it's an active component of Department of Justice. At the end of last year, they reported 91 pending criminal grand jury investigations. To me, essentially what that means is you've got 200 companies facing potential liability and some of their key executives who are being investigated. There's certainly going to be coordination between not only the FBI or other law enforcement or investigative agencies, but other regulators, financial or in health and human services as well. And then you're also going to have them cooperate with their international forces, other competition agencies, other law enforcement agencies around the world when it's an investigation into a multinational company. There are basically 4 areas, I think, based upon recent prosecutions that they're focused on. One is procurement corruption. You see lately those are the cases that the department's bringing in the antitrust field, less so the international sphere at this point. They're wrapping up a bunch of investigations that involve multinationals, but their focus lately has been on procurement corruption. You certainly have the financial services, FX, LIBOR investigations, where the Antitrust Division in 2015 collected over $3 billion worth of fines. As far as e-commerce and big tech, Carl spoke a little bit about the tech investigations that hasn't dripped over into collusion investigations at this point, but certainly when you've got experienced antitrust practitioners looking into and really peeling back the onion of these tech firms, they may uncover evidence not only of antitrust but other violations, criminal violations. What's relatively new in the antitrust sphere, and really the question mark is still out there, is what the division's going to do as far as their no poach and wage fixing policy that came out in October 2016, where companies who are competing for the same labor cannot agree not to go after each other's employees, or in the alternative, they can't agree on what type of wages that they will provide or benefits that they will provide those employees. So the antitrust came out and said that would be a criminal violation because it's an agreement among competitors. There's currently investigations that are ongoing. This is a difficult area of the law. As I mentioned before, the department has been active in its filing amicus briefs on this in Washington and in a couple of the districts on the East Coast. And so we'll see how that plays out, but that's something that companies should really take a close look at and see where, if their compliance programs address that type of antitrust issue. So with that, Carl, I'll turn it over to Carol unless you have any questions.
Jeff, thanks very much for that. And I'd like to introduce Carol Rendon, our partner in Cleveland, who's going to talk about corporate search warrants and dawn rates. Carol?
So good afternoon or good morning. I'm actually out in LA, so it's still morning out here. And so I'm going to apologize since I'm remote. I'm going to have to say next slide every time I need us to move on to the next slide. So for those of you listening, I apologize for that in advance. So next slide. I'm going to cover 3 different topics in the time that I have allotted to me this morning. Why there might be a search warrant executed as opposed to a subpoena or other means of gathering information. In general, information gathering by the government. And then for you all, best practices as you think about these things and try to be proactive in preparing for them. So next slide. So people often ask, why would the government execute a search warrant at a corporate headquarters? It's not a drug cartel, it's not a gang situation. Why wouldn't they just issue a subpoena? And so there are a number of reasons why we have increasingly seen search warrants executed in what are traditional white-collar cases. And those include concerns by the government with respect to the preservation of evidence and spoliation concerns. Also, significant concerns in the delays that are encountered when they simply subpoena documents from corporate targets, as we all gather, tens of thousands of emails, have to review them to see if they're responsive, have to review them to see if they contain privileged information. That process takes a long time, no matter how hard you work and how many folks you have doing it. And there are a lot of times where the government is simply not willing to wait, so they want to gather the information and gather it quickly. Also, using a search warrant as opposed to a subpoena makes sure that they get what they want, as opposed to filtering it through counsel and their review as to what's relevant and responsive to the subpoena. And then finally, and probably most importantly, there's also an incredible surprise factor when at the crack of dawn, as the business is opening, in come the agents with flak jackets on and often lights and sirens from local law enforcement, and they catch people off guard. And they use that to their advantage, in particular in their interactions with and efforts to obtain statements from employees. And so those are some of the factors that are in the government's mind as they're deciding whether or not they're going to approach taking an investigation overt via a subpoena versus a search warrant. So next slide. People often ask, what are the rules that govern the issuance of a search warrant? And it's covered by Rule 41E of the Federal Rules of Criminal Procedure. In essence, the government has to go to a magistrate judge in the district where the person or the place being searched is located. So, for example, I'm working on a matter right now. The investigation is being handled by the Southern District of Ohio U.S. Attorney's Office, but my client is in Georgia. And so the search warrant that they sought and obtained was from a magistrate judge in the district in Georgia where my client is located. That search warrant has to identify either the person or the property to be searched and the property to be seized. And it has to command the executing officers to execute the search warrant within 14 days and during daylight hours, unless a judge for good cause finds that they can execute it other than during daylight hours. And then, of course, they have to return the warrant to the magistrate judge who is designated in the warrant to certify that the warrant has been executed and to identify what has been seized. The Fourth Amendment mandates that search warrants have to describe with particularity the place to be searched and the persons or things to be seized. And all of those rules apply to searches of corporations in white-collar cases, not just to what we normally think of in terms of searches executed on drug organizations, for example. And then in addition, the search warrants will almost inevitably authorize the government to seize electronic data. And what's different about that is that when they come in, they don't have to spend the tens of thousands of hours sometimes reviewing the electronic data that the corporation has that's responsive to the search warrant or potentially responsive. Rather, they image everything. So they're going to image your server, they're going to image relevant computers, they may image phones so that they can preserve text messages. They're going to scoop all of that up, and then they're authorized to review it back in their offices after the search has been conducted. So that 14-day limit is 14 days for them to copy all of the electronic data on site, not to review the electronic data. So next slide, please. There's also a federal rule that governs how search warrants are executed. It's Rule 41F of the Federal Rules of Criminal Procedure, and it sets forth guidance for the law enforcement officers in terms of what they have to do when they're executing a search warrant. They have to note the date and time that the warrant is executed. They have to prepare and verify an inventory of the property that has been seized. And for electronic data, that means they have to describe the physical storage media that they seized or copied. That document's really important because it's your guide to what the government has taken from your premises. And then, of course, they have to provide the warrant and a receipt for the property seized, both to the entity that has been searched and promptly return the warrant and an inventory to the magistrate judge who authorized them to execute the search warrant. So next slide, please. So what happens when they show up? So first of all, everybody has to get over the initial shock of what it is that's happening. We strongly recommend that if you can, you send all non-essential employees home. There are a number of reasons for that. First and foremost, the agents are going to try to talk to anybody who's there. They're going to try to catch your employees off guard. They're going to try to get them to admit to things that may or may not be fully accurate in that panic moment as the employees are in shock as these agents come into their office space. So anybody who's not essential should be sent home. That also helps ensure that nobody accidentally or hopefully never intentionally destroys any documents or attempts to destroy any documents or other evidence as the search warrant is starting. There are, however, occasions where the agents will temporarily detain all or some of the employees. Bottom line, no matter what else, even if you would prefer to send people home, comply with the agent. The last thing that you want to do as the search warrant is being executed is engage in any conduct that appears to be an effort to obstruct the execution of the warrant. Next slide. So one big concern that corporations have when a search warrant is being executed is how do you protect potentially privileged material? And how does the government figure out whether or not it's seizing potentially privileged material? So oftentimes the government does in fact seize documents that are privileged, and there are remedies to address that after the search has been executed. But one of the things that we highly recommend that our clients do is try to identify things that are privileged wherever they are stored, whether that's a file folder that says attorney-client privilege on it, or attorney-client privilege in the subject line of privileged communications, flags that will allow you and the agents to identify things that should not be seized so that you don't have to address how to get it back after the fact. But what ends up happening most of the time is the government does sweep up stuff that is privileged. And they are required to put in place what is called a filter team. This is a group of attorneys and agents who are ethically walled off from the investigation, have nothing to do with the investigation. They review the documents and segregate out anything that might be privileged so that the team that's actually doing the investigation is not unintentionally tainted by having seen something that they should not see. But what we do on behalf of our clients is we go through the inventory and identify what has been seized, and then we proactively identify for the government, hey, I want to let you know this set of documents that you took, we believe those are privileged, and we oftentimes will provide them with a log identifying the materials that we believe are privileged. If they seize stuff that's privileged, one of the things that we can also do is file a motion under Rule 41G to seek the return of that privileged information. Next slide, please. So focusing for a minute on the search and seizure of electronic data. And this is something that is often overwhelming for clients. The government can seize all of this data without reviewing its contents. And then after the fact, they're going to go through and figure out what it is that they have seized. And that's one of the real challenges for corporations as they, in the wake of a search warrant, trying to figure out what the government is looking for or looking at, because all they know is that they imaged the following 15 computers and these custodians from the server. And we often don't know exactly what it is that they're looking at. And of course, as I mentioned, they will then have to have a filter team to prevent the improper review of privileged material. So next slide. So what can you do to be prepared for the possibility of this happening? It's the same sort of mindset that you need to have in place to be prepared for the possibility of a computer hack, for example. Nobody wants to think that their company could be subject to a criminal investigation or a search warrant, but if you are not prepared, you're not going to be able to handle it effectively in the event that it happens. Same mindset as, nobody wants to be the victim of a computer hack, but you need to be prepared in advance because the best defense is having a good offense in place. So you want to have a response team. You want to have identified in advance who are the people that are going to handle a search warrant if one should be executed at our location. And that'll be people from the legal department, senior management, senior IT people are critical, your media, public relations folks, folks from your security staff, and then admin people who will help you keep track of what's happening, what's being taken, who's being interviewed, really sort of help you record events in real time. You also want to have identified in advance who you're going to use as outside counsel. You do not want to be in a situation where there are agents at the door and everybody's scrambling, trying to figure out like, oh my gosh, who's a really good criminal defense lawyer, and calling all of your friends and normal civil lawyers that you use to find out who you should be calling. You should have that in your mind before it ever happens. You should have those numbers readily available so that you can call and get outside counsel in place, on the line, ideally in person, as quickly as possible. And then finally, you need to train your employees what they should do in the event that there is ever a search warrant executed at your location. And that's to cooperate with the agents to not destroy any documents or files electronically, and to make sure that your employees know who they should contact on that response team that you have in place. Next slide. So you also want to make sure that you have a checklist of the action items that you're going to undertake in the event there is a search warrant executed at your location. You want to have in place a pre-drafted email that you can send quickly, with just the press of a button, to all of your employees, letting them know what's happening and telling them what to do. And that should include, if they can go home, let them go home. If they're staying in place, cooperate with the agents, don't get in their way, don't destroy any documents, don't talk to the media, and also that they are allowed to talk to the agents, but they don't have to. Nobody is required in that moment to be interviewed by the agents if they don't want to be. It's a voluntary interview, and so you want to make sure the employees know what their rights are. You also want to have an understanding of what your insurance coverage is, because on occasion you will have coverage to help you with the costs associated with a criminal investigation on your D&O and other policies. If that's the case, you want to make sure that you alert your insurance company to what is happening in real time. And then, of course, you want to make sure that you have a really good plan in place for how you're going to interact with your investors, with the media, with others to whom you will have an obligation to advise them as to what's happening. But you want to do that in a thoughtful and well-planned process, not anybody talking to anybody off the cuff. Next slide, please. You also have to be ready to react, right? So you need to know, here's outside counsel, we're going to contact them, we're going to activate the response team. You need to make sure you ask the agent who they are and where they're from. Get copies of their business cards or copy their credentials. Make sure you know who has been at your location, their name and their agency. Make sure you ask for a copy of the warrant. The fourth bullet point is actually really important, and that is do not consent to a search or an expansion of the search. So when they come in with a warrant, they're going to show you the warrant. It's going to authorize them to search for specific information in specific locations. And then often they will say, hey, by the way, what's in that room here down the corridor? Would you mind if we just took a look in there as well? Yes, you mind. If it is not covered by the search, do not, even though it seems impolite, do not authorize an expansion of the search. If they have probable cause to search that room, they will go back and they'll get another warrant to search that room. Or they'll leave you with a subpoena requiring you to produce the documents that are in the areas that they were not authorized to search. But if you authorize the expansion of a search, you may very well undermine our ability to contest on your behalf the validity of both the search warrant and its execution. You need to then issue an internal document hold. If you've been the subject of a dawn raid, there is an ongoing criminal investigation, whether you knew about it or not, and you need to make sure that you are actively and effectively preserving documents going forward. And then, of course, identify which employees are non-essential and send them home as quickly as you can. Next slide, please. When the search is completed, these are the things that you're going to want to do with the assistance of your outside counsel. You're going to want to inventory, you're going to want to review the inventory of the items they seized. They will leave you with a copy of that inventory. That is the most important guide that we will have to figure out what the investigation is about and where the problems might be. You also need to very quickly debrief employees who were interviewed by the government. You want to know, while it's still fresh in their mind, what were they asked, what did they tell them, not only so that we know in real time what the nature of the investigation is, but are there red flags that have popped up in the course of those interviews? And are there things that we need to be looking at and addressing proactively? You want to make sure that you've got prepared statements that you can use with the media so nobody is inadvertently making a statement that becomes problematic in the wake of a search. And then, and this is slightly down the line, you will need to do an assessment with outside counsel of whether or not outside counsel can represent both the company and its employees, or are there employees who will need separate representation because they might be the subject of an investigation or a target of an investigation, and can that be pool counsel, or will you actually need to identify separate counsel for individual employees? And so with that, I will turn it over to George to continue our conversation.
Thank you, Carol. I'd like to introduce George Stimulaitis, who is our partner in the New York office, and he's going to talk about the FCPA. George?
Thank you, Carol and Carl. Before I get into that, antitrust and FCPA just have many similarities, and they're a natural tag team. Both share the core concept that essentially prohibition of conduct that injures competition. But most importantly, both should be emphasized in compliance programs, policies, and training. So just an overview of the FCPA. It was enacted back in '77, but it didn't really catch on to wide use until the 2000s. Similar to the way the RICO laws, which were enacted in 1970 to combat organized crime in the U.S., didn't really catch on until the mid-'80s. So, but with FCPA, once it caught on, it really was like a wildfire. And it was enacted for the purpose of making it unlawful for certain classes of people and entities to bribe foreign officials in order to retain or obtain business. It contains two provisions. One is the Antibribery Provisions. The other one is the books and records or accounting provisions. And it's enforced by both the DOJ and the SEC, both of which have their own specialized units to investigate and prosecute FCPA violations, rather. The thing I should emphasize here is it's not just the U.S. agencies that are focused on this, as everyone knows. You have DOJ, you have SEC, but you also, and anyone counseling clients on this, as we do routinely, we keep in mind and consider the implications under the UK Anti-Bribery Act, and then depending on what other countries are involved, whether it's South Korea, whether it's in 2018, a number of countries came out with their own versions: Peru, Argentina, Malaysia, India. France has its SAPIN 2, Brazil has its own version as well, Mexico, and a number of countries are involved. So that's something you need to consider. And just because it's legal under one country's laws doesn't mean it's legal under the FCPA, and vice versa. So those are all things to consider. So who's subject to the FCPA? Well, it's essentially three categories of entities or individuals. It's issuers, it's domestic concerns, and it's other people. By issuers, I mean any company whose securities are registered in the U.S. or who are required to file periodic reports with the SEC. That can include stockholders, officers, directors, employees, agents who act on behalf of an issuer. And interestingly and importantly here, issuers must adhere to both provisions of the FCPA, the anti-bribery provisions as well as the accounting provisions. To give you an interesting analysis on this, so take a football club like Manchester United. Well, they became an issuer back in the summer of 2012 when they did an IPO on the New York Stock Exchange. But just last month, they filed a Form 20 with the SEC in which they stated that they intend to continue to expand internationally and operate in foreign markets. And so FCPA is a concern to them now, too. That kind of makes the point. So domestic concerns, it's any U.S. citizen, national or resident of the U.S. or any business org with its principal place of business here in the U.S. or one that is organized here in the U.S. Stockholders, officers, directors, employees, agents, anyone acting on behalf of domestic concerns. Other people would be anyone who takes an act in furtherance of a corrupt payment while on U.S. territory. So the provisions of the FCPA, the anti-bribery provisions, they prohibit corruptly giving, paying, promising, offering, or authorizing payment of anything of value. And anything of value, you could have a whole CLE on it, but we'll touch on it a little later. But for example, it could be an unpaid internship to a relative of a foreign official. So it could be anything of value. And government has sometimes been aggressive in that regard. And so it prohibits payment or offering anything of value directly or indirectly through a third party. And through third parties is where a lot of this stuff can happen. To any foreign official, that should be in quotes because we got to give a definition of that, which I'll get to in a moment, political parties or candidates for the purpose of influencing an official in his or her official capacity or to secure an improper advantage in order to obtain or to retain business. So the accounting provisions of the FCPA require you to have companies to beef up their internal controls and continually enhance them, requiring companies to devise and maintain an adequate system of their internal accounting controls. The books and records provision requires companies to make and keep books and records that accurately and fairly reflect the transactions of the corporation. So if you're paying a commission, it should note a commission. It shouldn't be disguised as, payment for food or vendors or something else. As I said, the interpretation of foreign official, it's defined as an officer or employee of a foreign government or any department or agency or instrumentality thereof. The definition of instrumentality can be an entity controlled by the government of a foreign country that performs a function the controlling government treats as its own. There are factors that need to be evaluated there to determine whether a government controls an entity. For example, the percentage of interest it has in the entity, its ability to hire and fire leaders, and the extent to which the government receives profits from that entity. The Eskenazi case was a telecom company where the Central Bank of Haiti owned 97% of the shares and granted the company a monopoly over the telecom services. And that, of course, that was deemed to be an instrumentality. Whether other like joint ventures or intermediaries or state-controlled customers, those could also be considered foreign officials, and that remains to be seen. But I would assume that one wants to be careful about that. Interpretation. Another recent case was back in March. DOJ charged someone, former Uzbekistan government official who was the daughter of the former president there, with money laundering. And, she was alleged that she was a foreign official. She demanded allegedly bribes from various telecom companies for licenses, which led each of those to settle FCPA charges, which totaled in the fines paid or the settlements $2.6 billion. then on, the next day in March, DOJ released a revised version of its FCPA corporate enforcement policy. Those changes included clarifying disclosures made in the context of mergers and acquisitions, and also allowing for declinations when the FCPA violations were discovered post-acquisition. And oftentimes self-reporting any such then recently discovered FCPA violations behooves the entity that got involved in that combination. I'll address that in a moment. The revised policy also addressed DOJ's approach to cooperating companies' obligation with request to messaging software that self-deletes, just trying to keep up with the technology. On April 30th, DOJ released updated guidance on effectiveness of corporate compliance programs, and those provided factors for assessing how well a compliance program is designed, as well as if it's effectively implemented or not, and also determining the overall effectiveness of the program and how it's practiced. So, as I said earlier, there's a continued emphasis in DOJ's guidance that it puts out on self-disclosure and cooperation, and settlements with the DOJ continue to reflect that and include credit for voluntary self-disclosure, cooperation credit, and remediation credit. Interestingly, companies will only receive a partial credit if the self-disclosure or cooperation is deemed untimely. A recent case just last month, Quad Graphics, Inc., it received a declination letter from the DOJ pursuant to the enforcement policy, despite evidence of bribery committed by its employees, and the factors considered for that determination and declination were the self-disclosure, the thoroughness of the internal investigation by the company's counsel or outside counsel, cooperation, the nature and seriousness of the offense, and then the lack of any prior criminal history, and of course the remediation and the disgorgement that was already paid to the SEC. Another hotbed area, as I alluded to earlier, is hiring practices, and a number of cases, not surprisingly in the financial services industries. When you're dealing internationally, you had Credit Suisse on a Hong Kong case, Deutsche Bank, Barclays, you had JPM Chase, others who all got jammed up. And in the first instance, Credit Suisse entered an NPA, a non-prosecution agreement with the DOJ, paid $47 million in a criminal penalty, settled with the SEC administratively, and an order of payment of approximately $25 million in disgorgement and $4.8 million in interest. The allegations there was that a Hong Kong subsidiary of Credit Suisse hired, promoted, retained candidates referred to, related to, and otherwise connected with clients, potential clients, and government officials as part of a quid pro quo. Those hiring decisions were allegedly made principally on the basis of securing business from the referring official's employer, which were state-owned entities. Deutsche Bank, something similar, ended up paying $16.2 million to settle the charges with the SEC that it hired relatives of foreign government officials to improperly influence them in connection with investment banking business. Barclays paid $6.3 to settle charges with the SEC that it hired relatives and friends of foreign government officials to improperly influence them in connection with the investment banking business. So again, anything of value, as I said earlier, is something that you could have a separate CLE on, and it's not necessarily always intuitive, because you might think of an unpaid job would not be something of value, but it can be deemed to be something of value. So then there's the risk of bribery cases, and that's sort of a new, more aggressive area where if there's a risk of bribes and DOJ and SEC's interest in having companies protect against those risks. The Telefonica Brazil SA case resolved an allegation by the SEC that the company's internal accounting controls failed to sufficiently protect against the risk of bribes, and it ended up paying $4.1 million in civil penalty, with the SEC having alleged that while a code of ethics was in place, it was not followed, and there was a lack of internal accounting controls, compliance breakdown, and deficient internal audit function. Related to sporting tickets given to foreign officials who were in position to influence government actions affecting the company's business. So even though there was no bribery charge, it's something we need to focus on. Similarly, with Walmart, that resolved an investigation by DOJ and SEC for books and records violations and internal controls, the provisions of the FCPA. There was a 3-year NPA, non-prosecution agreement, and a external compliance monitor for 2 years, with Walmart paying a total of $282 million to DOJ and SEC to settle the charges. Again, in this instance, there was an allegation that Walmart was aware of some compliance failures relating to improper payments to government officials and internal controls failures, which allowed foreign subsidiaries to hire third-party agents or intermediaries without establishing sufficient controls to prevent those third parties from making improper payments. And there's a number of ways you can create those internal controls. You could have your third-party agents or subsidiaries file certifications that they're not doing anything improper. You can test down and drill into that, but at a minimum, you should make sure they're aware of your policies, that they're not allowed to do things, and they should have to certify that they're not doing it. So there's a continued focus on individual prosecution as well, with the Yates memo and DOJ continuing to be in force, in essence, a focus on individual accountability, even when companies are self-reporting and reaching deals with the government. A big part of what DOJ is doing is asking, who are the individuals who actually did this? Give us names, not just their titles. So in the first half of the year, charges were brought by DOJ against 11 individuals for FCPA violations. 5 of them have pleaded guilty to such charges. There was a recent trial where others were found guilty of a conspiracy to violate FCPA in the District of Massachusetts. Other examples as well, which I won't get into here. CFTC is another agency that need to focus on, because they announced that they're committed to investigating cases where there are FCPA violations of the Commodities Exchange Act, and they published their own advisory and announced a leniency program for cooperation and self-reporting. There's certainly more than enough of a business case for strict FCPA compliance. The FCPA investigations, prosecutions can have disastrous, sometimes fatal business consequences, large corporate criminal penalties, no longer just the cost of doing business. They could be outsized. They could take years to recoup such money. Criminal penalties of up to $2 million per anti-bribery violation, or twice the financial gain resulting from the alleged improper payment, and civil penalties as well, monetary, reputational damage, emotional on the staff and morale, possible prison sentences for up to 5 years, or fines of up to $250,000 for any culpable individuals, appointment of independent attorney monitors, debarment from U.S. government programs and denial of licenses and the like. Everyone likes top 10 lists, so some recent and not so recent, but the top 10 FTCA enforcement actions give you the staggering numbers there. If you look at, you're talking about almost $1 billion, and a lot of these over $500,000, and some of these others with monies going usually to both DOJ and SEC. You have quite a number of large dollar payments. It almost seems like it became the norm, and it's really something to avoid. That's basically the piece I have there. Carl, any questions? So we'll just check now to see if we have any questions from our participants who are dialed in. Does anyone have any questions?
Looks like, okay, this is Carl. Now would be the time to put your questions in. Let me, while you're doing that, raise some questions for the presenters that may focus you on some things they talked about. Let me start with Jeff Martino. Jeff, you talked about cartel prosecutions and the focus areas of those, but there was a time when the cartel prosecutions diminished, and there weren't a lot of prosecutions for a period of time when the new administration came in. Do you see that continuing, or do you see cartel prosecutions increasing? And if they are increasing, why was there this diminishing period in your view? Jeff?
Yeah, well, the results are in for the last couple of years, and the numbers are quite lower than they were the preceding 5 as far as the number of filed prosecutions that are public. You can look at the transition of leadership in the Antitrust Division as possibly one reason for that. Another reason is just they got off some very large investigations in auto parts, financial services, and it just takes time to ramp up a new investigation. These investigations tend to last 3 to 5 years. But as far as the leadership goes, and as I mentioned before, they're all there. They're just coming together within the last 2 years. They're brand new to those positions, although they've got quite a good amount of experience within the Antitrust Division. But you're going to see them start putting out more, I think, even more public guidance, and their prosecutions should follow. I wish I had a crystal ball to see if they're going to significantly improve, but as with any team, once you have your team in place, it's a lot easier to do the work.
Okay. Carol Rendell, let me ask you a question. You talked about search warrants, subpoenas. You specified privileged documents being segregated. Many clients on the phone obviously have in-house counsel, and they get advice from this counsel about various issues. There's sometimes a comfort factor that when you talk to a lawyer, it's privileged and confidential and cannot be revealed to anyone, including the government. Should clients be concerned that these privileges may not hold up when you're dealing with a government prosecution where you have things like the crime fraud exception?
So, Carl, that's a great question, and the answer is absolutely yes. Clients should be concerned. So, frequently in these cases that we handle, whether they're FCPA or False Claims Act or antitrust, any one of the myriad of criminal investigations that we handle for our clients, the government often takes the position that in-house counsel was part of the problem, and that as a result, because they were participating in whatever the government views to be the crime, that those conversations are not actually privileged. And so one of the things that we counsel our clients to do is also very difficult, by the way, for in-house counsel to have sort of the necessary ability to step back and have a perspective on what the government is looking at versus what their client, their company thinks was happening. So that's why we really urge our clients to make sure in these circumstances that they've got outside counsel in place. Those communications are far easier to protect, and we make sure that we note on all of our communications that it's attorney-client privileged. We are able to interact very effectively with the government and law enforcement and advocate on behalf of our clients, and do so with sort of a necessary distance between what may have gone awry or not and what the government thinks has happened. But it is really important for clients to recognize that those internal communications, just because a lawyer was present, are not necessarily going to be protected if it's in-house counsel as opposed to outside counsel.
Thank you, Carol. And as some of you may know, in the EU, the protections for in-house counsel on privilege is even less. You have to actually show that the counsel was independent of the company, which would by definition only include outside counsel. Let me pose a question to George Stembolitis, who talked about the FCPA. George, you showed a number of cases where bribes were actually paid, and the payment resulted in prosecutions and fines, etc. What about cases where the bribery actually doesn't take place? The money's not paid, but the business is retained or new business comes in. Is that sufficient for an FCPA prosecution if no monies are actually paid?
Well, it depends. It depends what hat I'm wearing. If I'm the government, yes, because the statute says prohibits corruptly giving, paying, promising, offering. So the mere offering, according to the statute, is the crime, is the violation. But if anybody's charged with that, give me a call and we'll work on your defense.
All right. Any other questions from the audience? We reached a 2 o'clock period. Well, thank you all very much for participating in this. We hope it's been helpful to you. Our third webcast in our series of webcasts between our antitrust and white-collar teams will be next week, next Wednesday, at the same time, 1 o'clock. And this one will focus on state attorney generals and what they're up to, and the presenters will be people who are very experienced dealing with state attorney generals. Thank you very much, and have a great day. Thank you.